I'd like to welcome everyone here and to introduce my associates. This is Jennifer Clark on my left. She's the law clerk that does most of the drafting for wills. Diane Verano, just on the left. She does a variety of things as a lawyer, of course. One of the main things is legal guardianships. Victoria Spray is the law clerk assisting Diane. She also does a lot of tax recovery work and asset exemption. Peter Zakar on the left, he's another associate lawyer, and he does primarily will drafting and trust preparation. And Karen Christie, who many of you already know, she does benefit increases, tax work, and asset exemptions, and those sorts of things. Do we have any questions yet? No, so no open questions. Does everyone realize that they can ask questions under Q&A, and that if you want to be anonymous, you can be? Would somebody please type something in just to make sure that everyone can see it? Hi, Janice, how you doing? Glad you can take part. There we go. That's very good. Thanks, everyone. Appreciate that. So our law practice specializes and focuses primarily only assists families who have kids with special needs and disabilities, and it's a lifelong practice. Just depends on when we come into contact with each other and how long you live, because we start assisting families from when the children are born, all through their lives, all through the parents' lives, right to the end of life, the whole arc. Everything from assisting with benefits and benefit increases and advocacy when the children are perhaps in supported living, or dealing with probate applications when parents have passed on, the setup and management of the trusts and dealings with RDSP, right through to the end when the beneficiary of the trust passes on as well. You can see here that it's actually 1 family in 10 in the province that has a child with special needs. If you look at the population of the province, and if you divide that by 3, which is what StatsCan suggests, it indicates the number of households. And if you look at the number of people on ODSP between the ages 18 and 65, and then you add a third again, because that deals with the people that are under 18 or over 65, you'll see that it's roughly, but truthfully, 1 family in 10 that has a child or a family member with special needs. So it's just that you feel crazy and alone from time to time, not that you are. And this is the statistics that ODSP provides. These are as of February last year. I don't think they've changed much, but what we find over the years, over the decades, is that the numbers increase. And there's, I think, various reasons for that. It doesn't clearly show any real distinctions. For example, it doesn't show Down syndrome or autism or any of those. It shows a few specific diagnoses, but it really is just sort of a broad description of some of the restrictions or dual diagnoses that some children have. So we're getting some questions. That's great. Everyone here will be answering questions in the background. I'll answer some of them. Hi, Ron. How are you doing? Ron asks, when do you actually have to set up a Henson Trust? Well, we'll get to that, but it's after the second parent dies. And of course, Ron, I know your situation. These are the numbers of people on ODSP in the different municipalities across the province. And for example, if you look at Ottawa, right here in Eastern Ontario, and if you look at the number of people on ODSP and the number of people in their households, then you can see that if Ottawa has a population of 1 million, which is what it says on the highway, that works out to be about 333,000 households. And so if you were to gross up this 25,496 to add in the kids under 18 or people, seniors over 65, you can see it's easily going to be 1 in 10. This number here, the 2024, that ACSD, that's a bit cryptic. The ACSD stands for Assistance for Children with Severe Disabilities, but it doesn't really turn on severity. That's not it. What it turns on is a lower or a modest household income for a child who's under 18. So if you have a household income of, for example, $40,000, then it's possible to get the equivalent of ODSP for a minor, and it tops out, last time I looked, at about $450 a month for ACSD for low-income households like this. So if you happen to fall into that, what this presentation, what all of our presentations is about, is these little nuggets of information that all of a sudden you say, oh, well, that would apply to me. So if you happen to be, for example, a single income household or perhaps a single parent household, then you could consider applying for ACSD for your child. And of course, when the child's under 18, you should also apply for special services at home funding for respite for yourself, and in fact, programming, camps, personal support, worker support, that kind of thing for your child. So special services at home, which is not based on household income, and potentially ACSD. Hi, David. How are you? This is the part that I enjoy most, is hearing from our clients and friends. This is something, one of the first things that we do is we look into whether it's possible to get more benefits for the child, for the household. And this applies to the 14% or the 48,000 people who are over 18 and still living at home or with family. You can see these numbers here. You see borders. Those borders are at home people on RDSP, and it's about 14%. So in those cases, what we do in many cases is we're able to increase benefits from $896, which is the room and board amount, to $1169, which is the shelter plus supplementary benefits. Our work is typically done on a contingent fee basis. And I asked Karen at the presentation yesterday evening what percentage she thought of there were of the clients that paid over time based upon the increased benefits. And Karen, I think you said about 55 or 60%. So it's a pretty painless way to increase benefits if it's possible. It's not always possible. The child has to have some ability to shop and cook. I did a quick calculation a little while back, and as a result of the work we've done, families are receiving about $1,645,000 more each year because of these increases, which is very gratifying. The motto of the firm is do good and do well. We couldn't continue to do good if we didn't do well, right? We have to have a living for everyone. But similarly, you can't just do good, rather do well. You know, what's life if all you're doing is doing well and you're not doing good? The other thing we do right off the bat for many clients is we put the disability tax credit and the caregiver credit in place. And typically, we wind up with a 10-year recapture. This is just the most common profile. It's not the same for every family, but it's the most common profile, that either the credits weren't used or they were used to be used, but then when the child went into supported living or moved out on their own, the parents stopped using these credits because they thought the child had to reside with them. Or they only use one of these credits because they thought they could only use one of these two credits. So what we do is, one of the first two things we do is we look to see whether benefits can be increased and whether there's any possibility of putting in place and recapturing disability and caregiver tax credits. We'll go into more detail about that in a moment. I see we're getting lots of questions. We had hundreds and hundreds of questions last night. We had, as I say, 451 people take part, and we now have 315 taking part of 553 that are registered. So this is about the average kind of number that we have. Just for reference, there's going to be a lot of information here to take in the next hour and a quarter. We hope to be done by about 1:15. But you will receive, everyone registered will receive the recorded video and the PowerPoint slides. Let's see if I see any more names. Oh, there's Pat. How are you? Good show. Pat again. Just humor me here. Hi, Fitz. How are you? So next topic is if your child is approaching age 18 and you know about provincial disability benefits, what would it take for the child to qualify? Well, the simplest test is that they can't function in a competitive workplace, or they can't function in the community, or they can't manage personal care. So those are the three sort of tiers of increasing restrictions. I would say the most common is that the child can't function in a competitive workplace or can't function in the community. There are lots of kids who also need help with personal care. One of the most common elements here, the strongest motivations for our families, is while alive, they're concerned that their child could be manipulated or taken advantage of or abused. And so, of course, they're ever vigilant until the moment they die, protecting their child right from the day they're born, obviously. But the other is what will happen to my child when I'm gone? And when we get to that point, we'll be talking about wills and Henson Trusts to continue to provide for the child when the parents are gone. You can see here that a child could receive on their own, the current rule is that they could receive gifts or voluntary payments of up to $10,000 over 12 months. But that's really just money given directly to the child if this is appropriate. Lots of times you wouldn't give the money directly to the child. So you can spend any unlimited amount of money you want on the child while alive. And similarly, when you're gone, the Henson Trust can spend unlimited amounts as well to provide for the child. But there is a simple rule that if you're giving money to the child and it's a bank transfer or trackable, that sort of thing, it's supposed to be limited to $10,000 over 12 months. But there's ways around that. I wouldn't spend a lot of time worrying about that part. And the asset limit is now $40,000 for a single individual. It used to be $5,000. It's comical because it used to be a $6,000 over 12-month gift rule, but a $5,000 asset test. So you could give somebody $6,000, they just could only keep $5,000 of it, which I thought was pretty comical. So once we have determined if we can increase benefits or reduce taxation and recapture taxes and so on, we're trying to put money into our clients' pockets. We look at whether the child is in fact at all approved for the disability credit, and that has an added step to be able to reduce taxes and recapture money. So we look into this, and you can see here that there's some information. And we also look, sorry about that. There we go, sorry. We also look into the Caregiver Credit. This is a much less often used credit. General knowledge about this is modest. And what it is, it's a separate tax credit that comes into play when the child's 18 or older. And up until 2017, you could only use it, that 14% of people that I mentioned, the 48,000, only people whose child lived with them could use the Caregiver Credit. But in 2017, they removed the reside with criteria. And what that means is that about 385,000 families can make use of this credit, not just $48,000. And it reduces your taxes by about $1,000 a year. So that's 385,000 times 1,000, sort of starts to add up. But people don't really know about this credit. And we often find that the recapture can go back for 10 years because the child did, of course, when they were young, until a certain age, they did live with the parents. And then perhaps they went into supported living or their own semi-independent living. So you just have to sort of tweak it a bit and backfile back to 2017 if the child's not residing with the parent. And that's the limit if they're not. But if in the 10-year period they did also live with the parent, then you can recapture those years too. You can see here that the line to look at is 30450. Now, you should double check too. If you're not using 30450, which is the adult dependent with a disability, you might be using line 30400 or 30425, which is the adult dependent, but not with a disability. So you could use those too, but this is the optimum line to use. So if you take a look at it and then you find not using it, let us know and we'll see if we can assist you. How are we doing with questions? Victoria, I've gone through several slides. Did you want to ask any specific questions of anyone panelists that are taking part?
Yeah, so we have one question from Tim. He asked, our daughter is recently married and her monthly rent has now significantly increased. Will this impact her ODSP?
Well, she won't get more ODSP. Mm-hmm. Why would the rent increase because she's married? A larger apartment. What would impact ODSP is if her partner is working, because that income would affect the ODSP. She would be part of a benefit unit. And of course, if any member of the benefit unit, her partner, is working, then of course that income would affect benefits. Now, of course, the amount of benefits for a couple is about $1,900 a month, more if they both have disabilities. But the problem typically is that people want to get married. It's an honorable estate, nothing wrong with that at all. The problem is that as long as they're living together but keeping their finances separate, the one party can be on ODSP and the other party can be employed, and there's no problem. They're just keeping their affairs separate. They're just very, very good friends. But once you get married, it changes things. Are there any other questions?
We had one question about having to reapply for the disability tax credit and if that process is different from an initial application.
No, it's the same thing. And it's curious. There's no rhyme or reason to it. We have people whose kids have Down syndrome or autism or other physical disabilities who are approved until age 18. There's no sense to it. But you do have to apply again using the T2201 form. The form has changed since you last used it, and there is an online procedure now for a doctor to complete the form that no one's ever really familiar with. It just came in August. But it is the same process. What the wisest thing to do is, if this is appropriate, is to just get a copy of the one that was the T2201 that was previously approved, do the same thing, and if possible, get it signed by the same doctor and file it. Are there any other questions about tax credits or benefit increases?
We have just one question actually in the Q&A chat here, asking if the disability tax credit increases if you have more than one person with a disability living with you.
Yes, either each person gets the full amount, or if it happened to be a couple, they would get the equivalent of 2 times the single amount. If it's just a couple and only one has a disability, it's about $1,918. All right, let's go on to the next. So this is probably one of the biggest implications for the disability tax credit. Saving taxes and so on is fine, right? But if the child is approved for the disability tax credit, they can have a registered disability savings plan. And if you use a child who's 18 or over as an example, then the grants and bonds are based upon the child's income, where prior to that it would have been based upon the parent's household income. And so normally the parent's household income would exceed the $35,000 that allows the child to have a bond, $1,000 bond every year, but perhaps doesn't exceed the $95,000 that would disqualify them for the full $3,500 grant. But if you take a simple example, the most common example, a child who at age 18 is on RDSP, then their income at best is about $14,400, unless they're working, of course. But point being that if someone who uses the tax credit, for example, the parent, uses the disability credit, it reduces their taxes by $1,600 a year. And if they use $1,500 of that and put it into the RDSP, which is the child's property, then there'll be a $3,500 grant, plus they will also get the $1,000 bond, which they'll get anyway, just for opening up the RDSP. So this is big. And to give it some context, if you do this for the 20 years from when the child's 18, and you invest the money at 5%, then by the time they're 60, it amounts to about $700,000, and it starts to pay out to them at about $30,000 a year for 24 years. So this is significant as far as estate planning for the family is concerned, and it's never happened before. The RDSPs came into place in 2008 in December, so let's just say 2009. So now what's happening is people are starting to see that it's amounting to a large sum of money. The problem is we, in every case that we can, we review the RDSP statement to see what kind of rate of return the person's getting. And the problem in practice is that unless you have a financial advisor to help you to properly invest, or you're self-educated, you could have lots of financial literacy, but unless there's some proper investment happening, all you're doing really is accepting the grants and bonds, getting some small squiggly amount of money, from the bank, and perhaps losing to inflation. You would this year, wouldn't you? And so age 60, what you've got is your 30,000 plus the government's 90,000 plus a little bit of growth, and there you are. So, if anyone has an RDSP and it's with a bank, and if you don't have an advisor to help you to invest that money in some appropriate way, I'd suggest that you have the RDSP moved to some investment firm. They can pull it from their end. It's not hard. And it would then be invested either, for example, with Investors Group, which has their own vehicle, or if you happen to be with, for example, Edward Jones, they'll put it with McKinsey Financial, and you'll get the proper advice to invest this money. We were sort of debriefing yesterday after the webcast, and given the number of questions that we're getting now that it's been 12 or 13 years, we're getting a lot more questions about RDSPs and when can you withdraw and so on. So I think that we're going to do an RDSP specific webcast in the new year. Are there any questions there, Victoria, about RDSPs?
Yeah, so one person asked, can you transfer an RESP to an RDSP?
Well, the answer is yes. There's paperwork involved. The net benefit is that, see, it's tactically not prudent to simply transfer all the money, but yes, you can do it. The only real advantage is that if you do follow that procedure, the income growth on the RESP rolls over into the RDSP. Otherwise, what you do is you simply cash out the RESP because it's the parent's property. Cash it out, and yes, it's true. It will have been invested in some prudent, cautious way, and the growth portion would be income to the parent when withdrawn. But if this is your biggest concern, I suggest you do something such as make a contribution to your own RRSP, and then take the return to capital that you've contributed plus any contributed capital, and then make payments over time. You'll certainly lose the RESP grants, right, the $500 a year, but over time, use this money at $1,500 a year to receive the grants and bonds on the RDSP. Now, if you feel like you don't want to do this, okay, fine. But if that's the case, why commit that capital to the RDSP when you can't then use it for the child effectively for decades or a couple of decades? Why not keep that money separate and then, as required during the child's lifetime, do good things with it? Now, if you want to plop the lump of money into the RDSP and let it grow over time, well, there's nothing wrong with that strategy. But you think about it before you just simply do it. Anything else about RDSPs?
Yeah. Can my son have beneficiaries to his RDSP? And I think Jen wanted to answer this one.
Yeah, please do.
I'm sorry, what was the question?
Can my son have beneficiaries to his RDSP?
Okay, basically, so if the child is capable of making a will, the RDSP residue, if there happens to be any at the son's passing, will go to his beneficiaries pursuant to the child's will. However, if the child is incapable and cannot make a will, what will happen is that it will go through the law of succession, meaning that once the child passes away, and if there is any residue in the RDSP, it goes first to the parents if surviving. If parents are not surviving, then goes to the child's siblings, then to the child's siblings' children, that sort of thing. And yeah, so depending on the scenario, whether the child is capable of making a will determine how the residue of the RDSP goes to.
Yeah, thanks, Jen. Victoria, what happened there is that's the correct answer. The specific question was, can the RDSP be designated? But that's not really what's being asked here. The answer to that is no, there's no designation of an RDSP. But the real question that's being asked is, what happens if the child dies? Where does the money go? The designation is just, well, could it be designated, right? But the real discussion is, well, what happens to it when the child dies? Okay, any other questions? All right.
A lot of people have asked how to invest their RDSP.
You invest it just as you would anything else, TFSA, for example. For example, in December 2008, both RDSPs and TFSAs were introduced. And under the present rules, it's changed over the years slightly, but under the present rules, if you can put $6,000 a year into a TFSA. Of course, you can top up if you're old enough, you could put a lump sum as well. But the point is that if you set up a TFSA for your child when they're 18, and or you set up an RDSP for your child, if you put the $6,000 maximum into the TFSA, it's essentially the same as putting $1,500 into the RDSP and getting $4,500 grants and bonds. It's the same $6,000. So what happens is, for both of these investments, this is what happens. You start the investment when the child is 18, and you invest it at 5% with proper investment advice. I have lots of clients who get 5% or more. Unfortunately, I have lots of clients who get much less, like 0.5% since inception, simply because there was no advice at all. And of course, this works in the bank's interest, because the less you make on your investments, the more the bank makes on lending that money out. That's a bit simplistic, but it's correct. There's the same numbers again. So you just invest the same way you would, for example, for any other investment, such as a TFSA or an RRSP. you don't really need that. Are there any other questions about the RDSPs before I move on? It's 12:30 right now.
We had a question asking how to increase the value of an RDSP and how to convert it to something else.
How to convert it to something else?
Yeah.
I don't know how you do that.
Well, that answers that question then.
Okay, that's lots about that. If anybody has further questions about RDSPs, just send an email. At the end of the slide pack here, you'll see there's an email address for Brent Lalonde, and you can send questions or concerns to him, and he'll pass them on to the appropriate person. Diane, I'm going to speak briefly here about guardianships and powers of attorney, and then if you'd chime in and explain it in a much better way than I would, I'd appreciate that. So one of the common questions we get is, what's the difference between a power of attorney and legal guardianship? Briefly, you can sign a power of attorney just like you have. You know, you have a will and a power of attorney for your wife or husband. But you have to be competent to sign a power of attorney. Powers of attorney remain in force if you become incompetent after signing, but you can't have a power of attorney if you're not competent to sign it. In that case, what happens is at a certain age, both of the parent and the child, it becomes clear that it would be appropriate to have legal guardianship in place, appointing the parents, and if you're fortunate enough to have siblings of the child, perhaps siblings as well, to be the successor guardians once you're gone. And we'll get into more of the reasons about why this is the case. But you know, what I describe it as is parents getting to that awkward age where they're not old by any means, or 60 perhaps, got decades ahead of them, but they know about mortality, they understand that, and they realize that once the parents are gone, who's going to be the account holder on the RDSP? Well, siblings can't be the account holder unless they're legal guardians or have power of attorney. Who's going to apply for survivor pensions, which we'll get to in a moment? Who's going to keep the investments in the RDSP going? Who's going to receive the funds when the child turns 60? Who is going to have specific authority to deal with personal care for the child? All of these things that have been concerns for the parents all of their lives, and become a greater problem once the parents are gone, because the siblings or family members that are involved just they're not given as much cooperation and clout as the parents were. Diane, would you like to elaborate on the process for legal guardianship?
Sure, I'd be happy to. So the way that we do guardianship here is through a process called summary disposition. And what that means, it's going to be an application in writing. So there's not going to be any court appearance from our clients, from myself, or from the judge. The application itself is a pretty thick book. It's about 120 to 200 pages long. And it includes information of the allegedly incapable person. So just go through a list of their daily activities. Also, it includes reasons and affidavits by the applicants of why they're applying and their relationship to that person. And it's also going to include two plans. One plan is called the management plan, and that goes through a list of the allegedly incapable person's assets and properties. And in short, what we're doing with the plan is just showing the court what the guardians want to do after guardianship is approved. The other plan is called the Guardianship Planning. This goes through a healthcare plan for the allegedly incapable person. And again, we're explaining to the court what the applicants intend to do after guardianship is approved. And in most cases, you know, a lot of our clients are parents of the incapable person. So a lot of this information, a lot of the questions is something they can easily ask because they've had to take care of this person since birth. And then the other thing we have to include are evidence as to capacity of the person. So the way we do this is through the use of what's called capacity assessment reports. And it is capacity assessors that conduct these reports, and we need 2 of them. And the whole thing is bound, and it's put in a big book and it is given to the court. And then another copy is given to each applicant. And another copy is given to what's called the Office of the Public Guardian and Trustee. And what they do is they review the application, and if they have any questions, they write to us, because this is an application in writing, and we answer them in writing. And then also, if the judge has any questions, it's in writing as well.
That's pretty clear. Let's see what the next slide says. This is just more detailed information that you can read when you get the slides about what the two types of powers of attorney can be used for. A person is competent, if they're competent to sign a power of attorney at age 16 for personal care and 18 for property. Now, of course, in most cases, parents don't have a problem at the start, even if the child's not competent, because ODSP has no problem at all making you the ODSP trustee for the payments. They want somebody that they can give the money to. While the child's a minor, they generally don't have much trouble, especially when they're minors, with getting cooperation from doctors and hospitals. It becomes much harder once the child turns 18, because of course the default is that the privacy legislation doesn't allow doctors and hospitals to release medical information. So it can be much more difficult at that point. It's true that if the child is not competent, then you are actually their substitute decision maker. But what we find is that the substitute decision maker doesn't get the cooperation or have the clout that they want. They might get run-of-the-mill information, but the problem is that medical authorities, doctors, they're all very bright, right? They're all very smart, but they don't know better than the parents what's best for the child. And they're just supporting professionals just like us. I think the people who have taken part in these seminars before will know this story. But the way I like to describe it is that if you compare the supporting professionals and individuals compared to the family in the context of an egg and bacon breakfast, the chicken's involved, but the pig's committed. And that's just a fact. Family has skin in the game. We do the best we can, but I think it's very wise for any kind of supporting professional to have sufficient humility to realize that they're just helping. They're not the ones that actually have to deal with these issues on a day-to-day basis. So as a result, once a child and a parent reaches a certain age, and they realize that they don't need guardianship necessarily, but they know that if they just leave this issue, that the parties, the trustees, the family members that are coming after them, they'll need guardianship. And so what do? Do you leave this problem to them? Well, very few people do. Typically, the parents, as always, step up and say, well, no, I don't want to leave that problem. They'll have their hands full making sure that my daughter is well cared for, managing the trust for my daughter. I'm not going to leave this problem to them. Now, we do, whenever appropriate, put a provision in the trust, in the trust section of the will, to provide that the trustees may use funds to make an application for legal guardianship. There are some cases where parents, we're talking thousands of dollars here for legal guardianship, not tens of thousands, but thousands. And we have clients, of course, who can't really afford it right now. They may die millionaires because they own a home in North York, but they're not millionaires right now. In fact, they're having a hell of a time paying for the hydro. But besides that, we make sure that all of these pieces to the puzzle are put in place. Now, this is just some more information about guardianship. You'll receive these slides. This is an important piece If you're a teacher or a municipal employee, hydro worker, Bruce Nuclear, or a workman's comp WSIB employee, then you'll have a pension from those sources. And these are what are called provincial statutory pensions. There are statutory pensions in all the provinces. They're all very similar because, of course, they're all unionized. They're all public servants. So as a result, a lot of them have the same provision, and that is that when the parent with one of these pensions retires, they receive their pension. If they have a spouse, then when they die, they would pass on 2/3 of it, for example, to the surviving spouse. But if they have an adult dependent survivor child, then the child stands potentially to receive 50% of that original pension. So if you have a teacher who has a $60,000 pension, and you have a child with autism, and eventually you and your wife have passed on, and the child is 60, for example, then someone has to be their legal representative or legal guardian to apply for the pension and to receive it, because it's paid directly to the child, the adult child. It can't be directed to the Henson Trust. That's a common question. And yes, it would disqualify the party from ODSP, but 30,000 is better than 14,000. So this is something that a lot of people don't know anything about. You can sort of start the process while you're alive. You can put your child on record, but you can't really establish finally that they are an adult dependent survivor for OTIP or OMERS purposes, for example, until after the parents have gone. But you can certainly plan in advance to make sure that if, for example, the child is approved for the disability tax credit, that the credit is transferred to the parent and they're using it, which means that as far as Canada Revenue is concerned, they're helping with necessities, food, shelter, clothing, which would then, generally speaking, would satisfy the dependent part of an adult dependent survivor. Now, there's more to it than that. But this is obviously a big piece to the puzzle. When you start to look at a $30,000 pension, which has to be applied for by someone who's not competent, and a $700,000 RDSP, and the Henson Trust with a share of the estate after the second parent dies, you can see that this is a big picture. Now, I'm always happy to work with these big pictures because it's nice to have this problem. Do we have any particular questions, Victoria, about pensions like this? It's not something people ask a lot because they don't know a lot.
Yeah, so no question, well, not too many questions, but one question that I keep seeing is people asking if the federal government pension plan is included as an eligible pension plan.
Yeah, that's a common question. No, it's just the provincial statutory pensions. And for example, it's also not nurses, it's not a hoop pension. So it's unfortunate. Well, let's see where we are now. Here we are on Henson Trust. Jennifer and Peter, I'd like to have you two answer a few questions or make a few comments. We've got about 30 minutes left. Jennifer, could you speak to the special wording in the Henson Trust provisions and the fact that we often get questions. People say unsure about whether they have a Henson Trust because most of the wills you'll see don't highlight it. They don't specifically name it or point it out, which is why we do, just to save those calls. But would you speak to these, and then Peter, if you wouldn't mind, if you speak to the use of these trusts, both for families that have kids with special needs and for other children. Jennifer?
I would be happy to. Good afternoon, everybody. I'm glad that everyone had a chance to come out today. And so, yes, the most common question that we do get at our office is, I have a will, does it have a Henson Trust? Well, a Henson Trust is a particular testamentary trust that's put into the will, of course, and it has to have specific wording in order to make it a Henson Trust. So, for example, it must include absolute and unfettered discretion. This means that the trustee the Henson Trust trustee is the person who manages the trust, will have the absolute, like the final word on how funds will be dispersed to the beneficiary. Absolute and unfettered also means that all decisions in terms of investment of funds, disbursement of funds, will always favor the beneficiary. Also, we have the phrasing shall not vest. This means that the capital and the income shall not vest in the beneficiary. The only thing that the beneficiary will receive are payments that are made to the beneficiary by the Henson Trust trustee. So, for example, if a trust has $500,000 and the income that is generated is invested at 5% will be $25,000. However, if the beneficiary's needs are modest, they're in community living, they're on ODSP, they may not need the entire $25,000. Say they only need 10. So 10 is paid to the beneficiary by the Henson Trust trustee, and the remaining is reinvested into the Henson Trust to grow. Now, another thing that the Henson Trust has is what we call the reversal of the even-handed rule. The even-handed rule, we talk about there are that do not favor one class of beneficiary over another. In a Henson Trust, there are two types of beneficiaries. We have the capital beneficiary, which may be a person who may inherit any residue of the Henson Trust when the beneficiary passes away. And we have the income beneficiary, which is the beneficiary themselves who will receive payments from the Henson Trust by the Henson Trust trustee. Now, the Henson Trust refutes this even-handed principle by saying that all decisions in terms of capital and income investment and disbursement will always favor the beneficiary. And finally, what we have is, or so not finally, but the Henson Trusts themselves have no limit of deposit. It can be 200,000, 500,000, it could be $1 million. There's no limit to what you can put into a Henson Trust. And disbursements. While if the beneficiary is on ODSP, yes, ODSP has an income limit of $10,000 per year to be paid to the beneficiary. However, if for example, we do suggest to clients that, the Henson Trust trustee, the beneficiary, any support team that the beneficiary has, such as a sibling, get together and do up a budget. And we're talking about, budget for, rent, cable, telephone, food budget, clothing budget, that sort of thing. And then what can happen is that the Henson Trust trustee can make third-party lump sum payments, say to the rental agency, to cable, telephone, that sort of thing, and go over that $10,000 disbursement to make third-party payments to the beneficiaries. Like I said, the rental, TV, that sort of thing, and it may affect 1 month of ODSP benefits, but at the same time, the person's costs are paid for a year. You don't have to, and you're ensuring that the beneficiary will live in the style that, they would, wish, that their parents intendedly to have them accustomed to.
No, that's great. Thank you very much.
You're welcome.
I'm just going to jump in for a second, Peter. Question here, where did Phil go? Phil's asking, we had this question last night too, whether Henson Trusts are applicable in all provinces. Phil's specific question, as you can see, is common law provinces, but the case is that Henson Trusts are applicable in all provinces, including Quebec, although of course Quebec has its own unique type of will. But that said, if you have property in Quebec, as many people in Ottawa do, you have to take this into account. Do you have 2 wills, or what do you do about that? But to the point, it really is, Henson Trusts are applicable in all provinces, although there is a caveat for Alberta. It was commonly understood or agreed by the bar in Alberta that what are called discretionary trusts would disqualify a person receiving AISH, which is the Alberta version of ODSP. I don't agree. Henson Trusts are absolute discretionary trusts. The position of the Disability Benefit Authorities Administration in Alberta is the same as Ontario. Back when Mr. Henson died back in '85, it said that discretionary trusts were the asset of and blah blah blah. Well, of course, the court overturned that, and it was taken to appeal and by the province, and the application to appeal was declined, which reaffirmed the court of first instance. So, if it was contested, I'm content that it would be successful and effective. What did happen, interestingly, was recently, a year or two ago, legislation was put in place in Alberta that specifically allowed Henson Trust, and then it was rescinded by a new administration. I don't quite understand that part, why they would do that. Why, from a public policy perspective, when you're paying the pittance that you are for the supports for people with disabilities, it's extremely difficult to live on $11.69 a month. How can you do this? The parents, the family are always supporting people on ODSP, people with disabilities. The unemployment level among people with disabilities is very, very high. You can't live on this amount of money unless you happen to be, for example, in a geared to income unit, but okay, so you're still in poverty. Why would you take away the right of a family to support their child when you're dead, when you don't try to effectively police this when you're alive? Why, from a public policy standpoint, would you not keep these down to the minimum public amount? If this is the type of policy you're in favor of, why wouldn't you keep them down to the minimum that a person might maybe be able to survive on, and open the doors to the family providing additional supports? There's no effective limit while the parents are alive. They just pay third parties for goods and services. And then theoretically, what's happening here is that when a person dies, parents die, and there's a trust receiving a share of the inheritance or insurance proceeds or whatever, why would you try to restrict that? Makes no sense to me. Anyway, that's just my rant. I do that once or twice a day. Peter, would you like to speak to the use of trusts, both for people with disabilities and other family members?
As you probably gleaned from Jennifer's explanation, the primary purpose for a Henson Trust is to essentially shelter an inheritance that a disabled person might get from the various asset tests that apply to the various government benefits. So as you can imagine, if you just willed your $100,000 to your disabled child, ODSP would take a look at that and say, great, they don't need us anymore. So that's the main purpose for a Henson Trust. But, and I'm just going to quote, I don't know if you're familiar with this, but we have an ebook on the topic on the website that I highly recommend everybody checks out. But there are three main purposes as we see it for a Henson Trust. As you've heard, again, Jen and Ken talk about, the main one is to help plan for your child's care when you're no longer around. The other one, as we talked about, is to protect your child's ODSP and other government benefits when they do receive their inheritance, because again, you have trustees of this Henson Trust that disperse funds and ensure that any funds that go to the beneficiary remain beneath those asset test thresholds to make sure that they receive all of the assets that, or the grants and entitlements from the government that they're entitled to. But you can also use Henson Trust in situations where you don't necessarily have a disabled beneficiary, but you might have somebody who has trouble managing their finances or who you'd want to protect in some other way. These kinds of absolute discretionary trusts could apply to those situations as well. And I know Ken actually has a great example of situations where those apply.
Excellent.
Yeah.
I remember one in particular, because the trusts are available for any family member. What happens is if you have a child with special needs and you set up a trust for them, as you would, and you also have another child who, for example, happens to be in a high tax bracket, more power to them, and they have children, kids with no special needs, well, what you could do is you could leave that share for that child to a trust of which they are the trustee. The person on disability benefits can't be their own trustee, but the other, the brother, who's the well-compensated lawyer, for example, and has 5 children, well, that guy could be his own trustee, and he would be a beneficiary along with his children of his inheritance, which is received in the form of a trust and invested and generating income. That income would be declared in the hands of the children because you'd spend it on them. And so you'd then use their personal tax credits of $13,000 plus each year up to make sure that the child who would otherwise have received this money invested it and paid tax at perhaps a high rate. In fact, there's no tax, and it's much better to have the income earned by what you've worked your tail off to save for your kids, because you could have spent it. You didn't have to leave it for them, but you did. To use that income to help support your grandchildren rather than Canada Revenue Agency. That's, again, my humble rant for the day. I got a question here from Peter Lamont. Hi, Peter. Peter, there's a question here about a more further clarification of the absolute discretion. The trustee has the discretion to both distribute all. You could give the trust fund to the child, like, for example, if they're otherwise quite capable. You would rarely do this, but they're otherwise quite capable. So at age 65, they're not on ODSP. You could just give them the money. Or, because it's an absolute discretion, you can give them nothing. And there's really no way around this. No, I mean, we can have a more elevated discussion if you want, Peter, about, removal of trustees and all that. But that's the nature of the discretion. So, of course, you have to be careful. And what I find is that typically, of course, the siblings are the trustees of the trust. Now, families are getting smaller. The number of families that don't have siblings beyond the one child with special needs is growing. But aside from this, practical, tactical concern, if the other kids are the siblings, and if they also are the residual beneficiaries of the trust, then obviously there's a potential conflict of interest here. Potential. Because if they give less to their sister, they get what's left when she dies. So this isn't in most cases, not a practical concern, but it's something to discuss. Are there any other specific questions, Victoria, about wills and trusts?
Yeah, so we had a question asking who can be a trustee for Henson Trust if no family or friends are available?
Well, it could be a trust company. Could be a family or friend with a trust company because that family or friend doesn't want to do it all alone. So in effect, the trust company would do all the investing and dispersing and tax filings and all those things. But the family friend could stay in touch with the beneficiary, for example. Or you could hire a professional. The standard trustee fee is 1 to 1.5% of the capital amount per year. Now, bank trust companies, virtually almost all trust companies, aren't interested in something that pays less than, say, $5,000 a year. I mean, that's, again, not a big amount of money, but they do like the assets, right? They like to have the assets. So the standard compensation for executive trustees is 1 to 1.5% normally. And there is one trust company that will accept small trusts. And you could also, of course, pay a professional. You could agree upon some compensation scheme, which is based upon, for example, their hourly rate, to be simple, rather than 1%. You have to pay whatever it takes to get the right kind of trustee support. Let's see what else. Jen, I'm going to speak to this lifetime benefit trust just briefly here. So it's 12 o'clock or 1 o'clock now. If anyone has a sizable RRSP or RRIF, and they have adequate other income that, they will of course have to take into income that portion that is required every year as a RRIF, but perhaps they don't need to spend it. Perhaps they'll keep it set aside and invested. But if you have a sizable RRIF, the one possible thing to do is, rather than let it fall into your estate and be taxed at a high rate, what you could do is there's a mechanism to pass it over to a lifetime benefit trust in your will. It's a parallel trust They're separate from the Henson Trust, and it receives on a tax-deferred basis the RRIF. The trustee can only purchase a lifetime annuity, qualifying trust annuity, based upon the life expectancy of the beneficiary of the trust. But what this does, as you can see here, is if you had a $500,000 RRIF and it falls into your estate in December, and you have other high income, let's just say, you're going to pay tax at roughly 50%. Let's just take this as a very simple example. So, you know, half goes to the government and half is for your child. I'm not sure that's very equitable. So, sorry. So what you do is instead, you roll it over to the LBT. An annuity is purchased. It's got a guarantee period on it to make sure that based upon the annual payments, that enough years will go by that however, whatever happens, all of the capital will be paid back. And you can see here that if you use the personal tax credits of the beneficiary, the personal plus disability, and I have to get this slide updated because the numbers are just off touch. You can see that you're going to pay a certain amount of tax every year, $708, and that over the 20-year period, instead of paying $250 on death, you pay $14,000 over the 20-year guaranteed period. And of course, that's just the guarantee period. If the child lives longer, it pays longer. So you can see that this is a substantial savings. Now, it's not for everyone, but it's very appropriate in the right fact situation. I'm not going to touch that. This is consideration of life insurance. If you happen to be a female 50, you have an 18 or 20-year-old son with disabilities, perhaps you're a single mother, you could buy a whole life or universal life policy, and just using 100,000 payout as one example, because you can have multiples, obviously. But if you had a policy like this designated directly to the trust, and it has a monthly premium of this amount times 12, works out to an annual premium of about $1,400. Now, the child's over 18, and in 14% of the cases, the child's living with you and may well be living with you until you die. So they're getting $896 or $1,169 a month. And you can see that $1,169 is very, very close to the annual premium. So what you do is you have a child living with you, for example. You purchase this life insurance upon your death, whether it's next year or just closer to your full life expectancy. It pays the $100,000 directly and quickly into the Henson Trust, because it may well be that now, perhaps just before you passed on, you were able to set up an apartment for the child, and the child is living semi-independently, and they have a budget. They have to have a fixed budget because the $496 shelter component of the $1,169 Odsp, you can't rent anything for $496, can you? So you're footing the bill for another $1,000 a month. Well, you need to keep that up. So this would quickly pay into the Henson Trust and be invested. And you can see here that if you simply tried to save the premium to accumulate the $100,000, now this example, of course, doesn't presume compounding income. It also doesn't presume tax on that income. But if you tried to save the capital amount, it would take you 72 years. But your life expectancy is 35. So you can see that in lots of cases, it's a really dead simple way to segregate your concern about the fact that you're a 50-year-old mother, you don't have a large estate, and you want to make sure there's something there at least for your child. So let's ask some more questions. We have about 10 minutes left before we're done. Victoria, do you want to allocate questions, or should we just pick them and answer them?
Yeah, I have a few. So one person was wondering, what if the person with a disability refuses to be assessed? And I think Diane wanted to answer this one.
That's a good thing for Diane to do, yeah.
So we get that question a lot. In our experiences, we haven't encountered it. What we have encountered are questions of, maybe the child has a short attention span, or has, not like everyone else, good days, bad days. And it's about choosing the right day that would maximize the answers we could get from that person. If that doesn't work, then we might seek an order from the court to get a capacity assessment ordered.
So another common question that we've been getting a lot is when a Henson Trust is actually set up. If Jennifer wants to answer that one.
Of course, I'd be happy to answer that. The Henson Trust itself, like I say, I'll backpedal a bit to say that the Henson Trust is the provision that's written into your will saying that your child's share will go into a Henson Trust. In a nutshell, it usually means like after probate is done on the estate and the beneficiaries are ready to be paid out, then the executor will go to a bank and set up the Henson Trust account with whatever bank they want to set up with. Now, usually when I talk to my clients about the after process, that's usually is how I say it. It's like after probate is done and the beneficiaries are ready to be paid out, the Henson Trust account is set up at the bank. However, people may want to amend my answer because that's usually, I'm not as familiar with the probate process as some of our other associates.
And then there was a question that a lot of people have been asking is if they can leave property in their will to their disabled child. Peter, if you wanted to answer this one.
I think that is probably context specific. There are various ways that you can leave property. Sometimes it might be more appropriate to leave it by, for example, having someone come on as a joint tenant, but there you have to be careful about, for example, if there are siblings that could cause problems down the line. There are also other implications. For example, it would depend on when you purchase the property. If it was long enough ago, then it might not need to go through what's known as probate. And probate is a process where you essentially have to take the will to court and have them approve of how everything's passing down. So really, it might not be a satisfying answer, but it is context specific, and it'd be a good idea to get in touch with us to discuss your particular situation.
Yeah, that's right. We have, I see there's one question about RDSPs and RRIFs, and Shane's asking, can you leave a RRIF to an RDSP? You can, of course, but it's limited to 170,000 typically, because the maximum contributions are 200, and you want to contribute 30,000 to get the grants and bonds. So you could, what you would do actually is you designate the RRS, the RRIF, to the child, the beneficiary, the owner of the RDSP. And of course, they then have to make an election, just like a spouse, to receive it. And then they have to make another election, and there's paper on both of these choices, to then transfer it into the RDSP. And again, if that's part of your plan, which, we would discuss all these things, then of course, if the child's competent, that's fine. But if they're not, the election has to be made, excuse me, by the legal representative or the legal guardian of the child on their behalf. So, there's further implications. And of course, if the child has cognitive disabilities, which implies that they may have trouble managing such an asset, obviously, but if they have cognitive disabilities, they could receive up to $100,000 RIF, and that would just be within an inheritance exemption, a sole inheritance exemption that could apply to it for ODSP purposes as an exempt asset. So you could leave directly 100,000 up to the child. You could leave another 170 that they could then roll into the RDSP, and then if there's a further chunk, then you could use an LBT. The thing to keep in mind about directing this money directly to the child is that then they have 100 plus 170, $270,000. And even if they draw it out, for income tax purposes, it's all a good process, right? But it's their money. So obviously, you'd have to look at the ramifications of, can they do a will? If they can't do a will, then what about succession law? Because obviously if they don't have a brother or sister, parents are gone, no brothers or sisters, then this kid dies. Well, there's a succession law tree, and simply put, it could well wind up in the hands of the cousins who never came to see the kid. So I won't go further on that part. And then even if the kid can do a will, do you want them to do a will? If you have a child who has delusions, would you want them to realize that they've got this asset, they can do a will, and they're going to leave it to who knows? Or would you rather that you find a way to pass it to the LBT because you can determine where the residue goes when the child dies? So those are the ramifications of those things. There's lots of tactics. People come to us all the time, and they're presenting what they've read on the internet about, I want to do this. Well, maybe they do. But what about these options? Oh, you're right. That's a lot simpler. So we have that kind of discussion, and it's toughest in dealing with the smarter clients, because the smarter clients, by definition, are smart, and they've succeeded in life. They've advanced along the path they've laid out, and one of the reasons they've done that is they've had all sorts of foresight and options and considerations, and so we wind up, having more discussions with people that are smart sometimes, because sometimes they're just too smart by half, and they're often the ones that come to us saying, well, I want this. And so we then have to listen and talk and discuss and say, well, yeah, that's one solution, but have you thought about that angle? So it's always a one-to-one discussion in each situation, and that's part of why it's a lot of fun. It's 1:13, so we have 2 minutes left. Are there any final questions, Victoria?
We had one question in the Q&A section from James Graham.
Oh,
He was asking, if the income is reported from the trust in the ODSP recipient's name, does it affect ODSP benefits?
Sorry, say again.
If the income is reported from the trust in the ODSP recipient's name, does it affect ODSP benefits?
Well, if the there's two or three answers here. If the money has been spent on the child, then it can certainly be included in income in the child's hands, which you want to do, because you want to use their personal credit so you don't pay tax in the hands of the trust. If it's being, if an election is being made, a preferred beneficiary election, to simply attribute the income, our experience is that although you have to explain this to the frontline staff and they have to talk to their lawyers in the back office and so on, those kinds of elected income, it's just phantom money. So the attributed income, say $70,000 on a large trust, that income is just attributed, so it's not true income. Money truly paid either to them or for them can be declared in their hands, so that using the paid or payable rule. And of course, if you're going to be giving the child more than the $10,000 over 12 months, then you have to know the techniques to do this without having any kind of serious effect on their RDSP benefits. You can do all of those things. See, three people have raised their hands. Does that mean that we should ask them specific questions, or what does that mean? Let me take a look. No. Well, we have 255 people left. It's now 1:15. I think we'll have to call a halt now. That's all the time we have available today. But everyone will receive every so often emails or invites to follow-up seminars, and we'd be happy to take part in the next one. This is an annual update session. We do this every year. And I think the next one will probably be an Ask the Expert Q&A, and it's possible that it may take place in the middle of December. So just stay tuned, and we'll be happy to talk to you all again. With that, thank you for taking part.